I never expected that putting up a few business signs would turn into a constitutional law battle. But that's exactly what happened when the Meadowbrook Heights HOA decided to target my snow removal company. My name is Aaron Gallagher, and I've been running Gallagher Snow Services in suburban Denver, Colorado, for the past 5 years. It's an honest business that I built from the ground up, starting with just a beat-up pickup truck and a snowplow I bought used from a retirement sale. Now I have 3 trucks, 2 employees, and enough clients to keep us busy through the entire winter season. I'm not getting rich, but I'm making a decent living doing something I'm good at. The whole mess started on a Tuesday morning in early November. I was driving through Meadowbrook Heights, one of the nicer subdivisions in Lakewood, handing out flyers and putting up my yard signs at houses where I already had permission from homeowners. These weren't random signs I was sticking in people's yards. Every single one was placed with the property owner's approval. I'd either knocked on doors and gotten verbal permission, or they were repeat clients from last year who specifically asked me to put signs up again. The signs themselves were simple and professional. White corrugated plastic with blue lettering that read Gallagher Snow Services, along with my phone number. Nothing flashy, nothing offensive. Just standard business advertising that you see in neighborhoods all across America, from lawn care companies to real estate agents to home security systems. I was hammering in my 7th sign of the morning when a silver BMW pulled up beside me. The window rolled down, and I saw a woman in her late 40s with an asymmetrical blonde haircut that probably cost more than my weekly grocery bill. She wore oversized sunglasses despite the overcast sky and had that pursed lip expression that I'd come to recognize as trouble. "Excuse me," she called out in a tone that made it clear she wasn't actually asking to be excused. "What do you think you're doing?" I straightened up and gave her a friendly smile, the kind I'd perfected over years of customer service. "Morning, madam. Just putting up some business signs for homeowners who requested them." "Those signs are not permitted in Meadowbrook Heights," she said, her voice sharp enough to cut glass. "I'm Karen Atwood, president of the Meadowbrook Heights Homeowners Association, and you need to remove those immediately." I felt my jaw tighten, but I kept my voice level. "With all due respect, Mrs. Atwood, these signs are on private property with the owner's permission." "I'm not violating any laws." She removed her sunglasses, revealing eyes that could freeze boiling water. "Our HOA covenants strictly prohibit commercial signage of any kind. Every homeowner signed these covenants when they purchased their property. Those signs are a violation, and if they're not removed by the end of the day, the homeowners will be fined." "That doesn't sound right," I said, pulling out my phone. "The Supreme Court has ruled on commercial speech multiple times. Property owners have rights." "The Supreme Court doesn't govern this neighborhood," Karen snapped. "I do." "Well, the HOA board does, and we have rules that everyone agreed to follow." She glanced at the house behind me where I just planted the sign. "That's the Morrison residence. I'll be sending them a violation notice today." "Madam, this is how I advertise my business. I'm a small business owner trying to make a living. These signs don't hurt anyone." "They're an eyesore and they lower property values," Karen said, as if this were an indisputable fact handed down from on high. "Meadowbrook Heights maintains certain standards. If people want to live here, they follow our rules. If they want to advertise their little businesses, they can move somewhere else." The condescension in her voice when she said little businesses made my blood pressure spike, but I forced myself to stay calm. Losing my temper wouldn't help anything. "I'll look into the HOA covenants," I said. "But I'm not removing the signs unless I'm legally required to." Karen's mouth formed a thin line. Then you'll be hearing from our attorney and possibly the police. Have a good day." The window rolled up before I could respond, and she drove off, leaving me standing there with a hammer in one hand and my phone in the other. I called Tom Morrison, the homeowner whose yard I'd just put the sign in. He picked up on the third ring. "Hey, Tom, it's Aaron from Gallagher Snow Services. Quick heads up, I just had a run-in with your HOA president about the sign in your yard." "Oh, let me guess, Karen Atwood." Tom sighed audibly. "That woman has made it her life's mission to control every blade of grass in this neighborhood. What did she say?" I explained the conversation, and Tom groaned. "Aaron, I appreciate you calling, but honestly, don't worry about it. She threatens people constantly. Last month she tried to fine the Hendersons because their mailbox was the wrong shade of black. The month before that, she measured everyone's grass to make sure it wasn't over 3 inches. The woman is unhinged. She mentioned fining you if I don't remove the sign. Let her try. I want your sign up. You do great work, and I'm happy to have you advertise in my yard. Besides, I actually read my HOA covenants when I bought this place, and I'm pretty sure there's nothing in there about temporary business signs. She's probably making it up." That made me feel a bit better, but I couldn't shake the uneasy feeling in my gut. I'd heard horror stories about HOAs before, about people losing their homes over ridiculous violations, about boards that acted like miniature dictatorships. I'd always been grateful that my own house was in an older neighborhood without an HOA. I continued my route through Meadowbrook Heights, putting up signs at 6 more houses where I had permission. At each stop, I half expected Karen to reappear, but she didn't. I finished around noon and headed home, trying to put the encounter out of my mind. That evening, I got 3 phone calls from clients in Meadowbrook Heights. All of them had received formal violation notices from the HOA, demanding that the unauthorized commercial signage be removed within 48 hours or face a $500 fine. The notices were printed on official HOA letterhead and cited Section 12.7 of the Meadowbrook Heights Covenants, which apparently prohibited signs of a commercial nature except those advertising the sale or lease of the property on which they are located. I asked one of my clients, Janet Rodriguez, to email me a copy of the full covenant document. When I read through it that night, I found the section in question. It was vague and broadly worded, but it was there. However, something about it felt wrong. I wasn't a lawyer, but I remembered reading articles about HOA rules being challenged on constitutional grounds. The First Amendment protected freedom of speech, including commercial speech to some degree. Could an HOA really override that? I decided I needed professional help. The next morning, I started calling lawyers. Most of the attorneys I reached weren't interested in taking on an HOA case, especially not one about yard signs. "Not worth the hassle," one told me bluntly. "HOAs have their own attorneys on retainer and they'll drag it out forever. You'll spend more on legal fees than you'd lose just taking the signs down." But I wasn't ready to give up. This felt like more than just signs. It felt like a matter of principle. I had worked hard to build my business, and I relied on word of mouth and visible advertising to bring in new clients. If Karen Atwood could shut me down in one neighborhood, what would stop other HOAs from doing the same thing? On my 9th call, I reached the office of Patricia Chen, an attorney who specialized in First Amendment cases. Her paralegal put me through after I explained the situation. "Mr. Gallagher," Patricia said, her voice crisp and professional, "tell me exactly what happened." I walked her through everything, from putting up the signs with permission to Karen's confrontation to the violation notices. Patricia listened without interrupting, and I could hear her typing notes. "Have the police been involved?" she asked. Not yet, but Karen mentioned possibly calling them. Interesting. And you're certain every sign was placed with the property owner's explicit permission? Absolutely. I have it in writing for some and witnesses for the others. I never put up a sign without asking first. Patricia was quiet for a moment. Mr. Gallagher, I'm going to be honest with you. HOA cases can be complicated and expensive. However, this particular situation raises some compelling First Amendment questions. The Supreme Court has held that homeowners have a right to display signs on their own property, and that right extends to some commercial speech. There's a case called City of Ladue v. Gillio that's particularly relevant here. So you think I have a case? I think you might. But let me be clear about what you're getting into. If we challenge the HOA, they'll fight back hard. They have money and lawyers and time. You'll need to be prepared for that. I thought about my business, about the clients who depended on me, about the principal at stake. I'm prepared. How much will this cost? My normal rate is $350 an hour, but I find this case interesting enough that I'm willing to work on a modified contingency basis. I'll charge you a reduced hourly rate up front, and if we win and recover attorney's fees from the HOA, you'll owe me the difference plus a percentage. Does that work? It was more than I wanted to spend, but less than I'd feared. Yes, let's do it. Good. First thing we need to do is send a letter to the HOA explaining why their covenant is likely unenforceable as applied to your signs. We'll cite the relevant case law and give them a chance to back down before this escalates. I'll draft that today and send it over for your approval. I hung up feeling hopeful for the first time since Karen had rolled down her window. Maybe this wouldn't turn into the nightmare I'd been imagining. Patricia's letter went out the next day via certified mail and email. It was 3 pages of densely written legal argument, citing multiple court cases and explaining in detail why the HOA's prohibition on commercial signs likely violated the First Amendment. The letter concluded by requesting that the HOA withdraw the violation notices and confirm in writing that they would not interfere with the signs going forward. The response came faster than I expected. On Friday afternoon, just 2 days after Patricia sent the letter, Karen called me directly. I was in my truck, finishing up a pre-season equipment check, when my phone rang with an unfamiliar number. "Is this Aaron Gallagher?" Karen's voice was even icier than before, speaking. "This is Karen Atwood from the Meadowbrook Heights HOA. I received a very interesting letter from your attorney. Did you really think threatening us with a lawsuit would work?" "I'm not threatening anyone, Mrs. Atwood. I'm simply exercising my rights and helping my clients exercise theirs." "Your rights," she laughed, a harsh sound that held no humor. "You don't have rights in Meadowbrook Heights. The homeowners signed covenants. Those covenants are legally binding contracts. Every court in Colorado has upheld HOA authority to enforce their rules. The First Amendment is also legally binding, Mrs. Atwood, maybe more so than your covenants." "We'll see about that. Since you've decided to involve lawyers, we're escalating our response. As of this moment, you are banned from entering Meadowbrook Heights for any purpose. If you set foot in this neighborhood, you will be trespassing, and I will call the police to have you arrested. Furthermore, every homeowner who has one of your signs will be fined $500 per day until the signs are removed. I hope your little crusade is worth it, Mr. Gallagher." The line went dead. I immediately called Patricia and relayed the conversation. I could hear the anger in her voice when she responded. "She's bluffing about the trespassing. A private citizen can't just ban someone from a neighborhood, and you have a legitimate business purpose for being there. As for the daily fines, that's almost certainly unenforceable. Most HOA covenants cap fines or require progressive enforcement. I'll need to review their governing documents more carefully. So what do? We wait. Let's see if she actually follows through on her threats. In the meantime, I'm going to start drafting a complaint for federal court. If they want to play hardball, we'll show them what hardball looks like. That weekend was tense. I kept expecting angry calls from my Meadowbrook Heights clients, but instead, something unexpected happened. They got angry at the HOA. Tom Morrison called me Saturday morning to say he'd organized a group of homeowners who were refusing to remove the signs. Janet Rodriguez sent me a text saying she'd contacted a local news station about the story. By Sunday evening, I had 8 homeowners in Meadowbrook Heights who were standing firm, despite receiving updated violation notices threatening immediate legal action. On Monday morning, everything exploded. I woke up to find 3 missed calls from a number I didn't recognize. When I called back, a reporter from Denver's ABC affiliate answered. "Mr. Gallagher, this is Rebecca Walsh from Channel 7 News. We've been contacted by several residents of Meadowbrook Heights about an HOA dispute involving your business. Would you be willing to go on camera to discuss what's happening?" I hesitated. Part of me wanted to avoid the media circus, but another part realized this could be exactly what I needed. Public pressure sometimes worked better than legal pressure. "Yes," I said. "When?" They sent a camera crew to my house that afternoon. Rebecca was a sharp woman in her 30s who clearly understood the story's appeal. HOAs were always good for ratings, especially when they were being unreasonable. The interview lasted about 20 minutes. I explained my business, how the signs worked, Karen's confrontation, and the legal threats. Rebecca asked good questions and let me tell the story without interrupting. She also interviewed Tom Morrison and 2 other homeowners who were willing to go on camera. The segment aired on the 6 o'clock news that evening, and by 9 o'clock, it had been picked up by the local Fox and CBS affiliates. By midnight, it was trending on social media. The narrative was perfect for viral outrage. Small business owner being crushed by power-hungry HOA president over harmless yard signs. The next morning, Karen made her biggest mistake. She called the police. I was having coffee and reading the flood of supportive messages on my business Facebook page when Tom Morrison called, his voice tight with anger. "Aaron, the police are here. Karen called them and claimed you're trespassing. Your signs are still up, and she's saying that constitutes an ongoing violation. The cops want to talk to the homeowners who have signs and they're threatening to remove them. I'm on my way. You shouldn't come. Karen said if she sees you, she'll have you arrested for criminal trespassing." "Let her try. I'll call Patricia and head over." I called my attorney while driving. Patricia was furious when I explained what was happening. "Do not engage with Karen," she instructed. "Be polite to the police. Explain that you have permission from property owners and film everything if possible. I'm leaving my office now. I'll meet you there." I reached Meadowbrook Heights 20 minutes later. There were 2 Lakewood Police Department cruisers parked on Morrison Street, and a small crowd had gathered. I recognized Tom and Janet among about a dozen homeowners. Karen stood apart from them, arms crossed, speaking to 2 uniformed officers. I parked and approached the group, my phone already recording. One of the officers, a middle-aged man with sergeant stripes, noticed me immediately. "Are you Aaron Gallagher?" "Yes, sir." "I'm Sergeant Davis. We received a complaint about unauthorized signs and possible trespassing. Can you explain your involvement here?" "Those are my business signs, Sergeant. Everyone was placed with the property owner's explicit permission. I'm not trespassing. I'm conducting legitimate business." Karen stepped forward, her face flushed. "He's banned from this neighborhood." The HOA has the authority to restrict access to non-residents. He's trespassing, and these signs are violations of our covenants. I want them removed immediately, and I want him arrested." Sergeant Davis looked tired. "Madam, for the third time, private citizens cannot ban someone from public roads in a neighborhood. Mr. Gallagher has broken no law by driving here. As for the signs, that's a civil matter between the HOA and the homeowners. We can't enforce HOA covenants. Then why did you come?" Karen demanded. "Because you called 911 and claimed there was ongoing criminal activity. If you abuse the emergency system again, you could face charges yourself." Karen's face went from flushed to pale. "I'm not abusing anything. I'm trying to maintain order in my neighborhood." "Your neighborhood?" Tom Morrison stepped forward. "Karen, you don't own this place. We do. These are our homes, our yards, our property. You work for us, not the other way around. I'm the HOA president, elected by the board to enforce the covenants that all of you signed." "Then call a vote," another homeowner said. I recognized her as Susan Chang, one of my clients. "If you're so confident the community supports you, call an emergency meeting and let everyone vote on whether these signs should be allowed." Karen looked like she'd swallowed something sour. "The covenants don't require a vote. They're already binding." A car pulled up, and Patricia Chen stepped out, looking every bit the high-powered attorney in a dark suit and heels. She walked directly to Sergeant Davis and introduced herself. "I'm Patricia Chen, representing Mr. Gallagher." "Officer, has my client been accused of any actual crime?" "No, madam. This appears to be a civil dispute over HOA rules." "Then I'd like to remind everyone present that the First Amendment protects the right of property owners to display signs on their own land, including commercial signs. The HOA's covenant provisions are almost certainly unenforceable as applied to these facts. If Mrs. Atwood continues to harass my client or these homeowners, we will seek injunctive relief and damages in federal court." Karen's eyes widened. "You can't sue us for enforcing our own rules." "Actually, Mrs. Atwood, we can, and we will. HOA immunity has limits, especially when constitutional rights are involved." Patricia turned to the assembled homeowners. "If any of you are facing fines or threats of legal action over these signs, please contact my office. We may be pursuing a class action lawsuit." That seemed to break something in Karen. She turned to Sergeant Davis, her voice rising. "Are you going to do your job or not? Remove these signs. Arrest this man. He's harassing our community." "Madam, I've explained multiple times that this is not a police matter. If you continue to make false reports, I will have to take action. I suggest you consult with your HOA attorney and handle this through proper civil channels." Sergeant Davis and his partner left. The crowd of homeowners stayed, and several of them approached Patricia to get her card. Karen stood alone by her BMW, looking increasingly isolated. Before leaving, she pointed at me. "This isn't over. The HOA has resources you can't imagine. We'll bury you in legal fees." "Actually," Patricia said calmly, "if we prevail on First Amendment grounds, the HOA will likely be ordered to pay our attorney's fees. So please, by all means, keep fighting. You'll just be enriching me and proving my client's point." Karen got in her car and drove away without another word. The next few days were a whirlwind. The news story went national, picked up by cable networks and websites. Suddenly, everyone had an opinion about HOAs and freedom of speech. My business phone rang constantly with supportive messages and new client requests, many from people who wanted to hire me specifically because they'd seen the news coverage. The Meadowbrook Heights HOA board held an emergency meeting that Thursday night. Tom Morrison attended and recorded the whole thing. According to him, It was chaos. Karen insisted they needed to fight, to defend the integrity of their covenants, to show that the HOA couldn't be pushed around. But several board members were getting cold feet. They'd been contacted by their insurance company, which warned that First Amendment lawsuits could be expensive, and that their coverage might not apply if they were found to have violated clearly established constitutional rights. One board member, a retired lawyer named Edward Price, apparently gave an impassioned speech about how Karen had overstepped her authority and created a public relations disaster. He moved to rescind the violation notices and allow the signs. The motion failed 3-2, with Karen casting the deciding vote. Patricia filed our lawsuit in federal district court the following Monday. The complaint was comprehensive, alleging violations of the First and 14th Amendments, seeking declaratory and injunctive relief, and requesting attorney's fees. We named the HOA as a defendant, along with the board members individually for acting under color of state authority. That last part was important. HOAs often tried to claim they were purely private entities, but when they enforced covenants that functioned like local laws, courts sometimes treated them as state actors for constitutional purposes. The filing made news again. The story now had everything: underdog small business owner, overreaching HOA, constitutional principles, and a federal lawsuit. Patricia gave interviews explaining the legal theory, and law professors started writing op-eds about HOA power and property rights. 10 days after we filed, the HOA's attorney reached out to Patricia. His name was Richard Benson, and he worked for a firm that specialized in representing HOAs across Colorado. Patricia put the call on speaker so I could listen. "Miss Chen, I've reviewed your complaint, and I think we may have room for a reasonable settlement here." "I'm listening," Patricia said. "My clients are willing to withdraw the violation notices and allow Mr. Gallagher's signs to remain for a period of up to 90 days per year, which is standard for seasonal business advertising. In exchange, Mr. Gallagher drops the lawsuit, and we agree that neither side owes the other attorney's fees." "That's not acceptable," Patricia responded. "Your clients violated clearly established First Amendment rights. They've harassed my client and the homeowners who support him." A time limit on the signs is still a content-based restriction that likely won't survive strict scrutiny. "We're prepared to take this to trial," Benson sighed. "Miss Chen, you know as well as I do that HOA covenants are generally enforceable. Courts have upheld all sorts of restrictions on signs. On political signs, sometimes. On commercial signs placed with property owner permission. The case law is much more favorable to us. Raid v. Town of Gilbert was just a few years ago, and it significantly strengthened protection for commercial speech. Your covenant is content-based, it's overbroad, and it's not narrowly tailored to serve any legitimate governmental interest. The HOA isn't a government entity, which makes it even harder for them to justify restricting speech. If they were a government, they might at least argue some compelling state interest. But they're not. They're a private entity trying to enforce aesthetic preferences that override constitutional rights. That's not going to fly. I'll convey your position to my clients." The call ended. I looked at Patricia. "Do you really think we can win this?" "Yes. The law is on our side. The question is whether the HOA board is willing to spend tens of thousands of dollars finding that out the hard way." As it turned out, they were, for a while at least. The case proceeded through discovery. We submitted interrogatories asking the HOA to explain the purpose and history of their sign restriction. They submitted their own asking about my business practices and the content of my signs. We deposed Karen Atwood, which was apparently quite an experience. Patricia reported that Karen spent 3 hours insisting she'd done nothing wrong, that the covenants were sacred, and that anyone who didn't like the rules should move somewhere else. We also deposed Edward Price, the board member who'd argued for backing down. He was much more reasonable, admitting that the sign restriction had been adopted years ago primarily to prevent people from running businesses out of their homes, not to ban temporary advertising by outside companies. He also testified that Karen had acted unilaterally in several respects, threatening legal action and calling the police without full board approval. That last part became important as the case developed. Patricia argued that Karen and the board had acted recklessly, knowing or should have known that they were violating constitutional rights. If we could prove that, we might be entitled to punitive damages in addition to attorneys' fees. Meanwhile, the media attention continued. A national property rights organization filed an amicus brief supporting our position. Several law professors wrote articles analyzing the case. And most importantly, other homeowners in Meadowbrook Heights started pushing back against the HOA on various issues. It turned out that Karen's aggressive enforcement style had created a lot of resentment over the years. The sign dispute became a catalyst for broader discontent. In early January, with snow finally arriving in Denver and my business hitting peak season, the HOA board held another emergency meeting. This time, Edward Price brought a motion to remove Karen as president. The motion passed 3-2. Karen stormed out of the meeting and immediately resigned from the board entirely. The new board president, a software engineer named Michael Chen, unrelated to Patricia, called my attorney the next day. He wanted to settle. The negotiations took 2 weeks. Michael was reasonable and genuinely apologetic about how the situation had been handled. The final settlement agreement was more than I'd hoped for. The HOA admitted that their covenant provision was unenforceable as applied to temporary commercial signs placed with homeowner permission. They agreed to amend their covenants to reflect this. They withdrew all violation notices and fines, and most importantly, they agreed to pay $75,000 in attorney's fees and $15,000 directly to me for damages. Patricia called me the day the settlement was finalized. "Aaron, you did it. You stood up for your rights and you won. This is going to set a precedent that helps other small business owners dealing with similar issues." I felt a wave of relief wash over me. I couldn't have done it without you. You did the hard part. You refused to back down when it would have been easier to just fold. That takes courage. The settlement was finalized in late January. The HOA held a special meeting to vote on the covenant amendments, which passed overwhelmingly. It turned out that most residents had never supported the sign restrictions anyway, but Karen had enforced them so aggressively that people were afraid to push back. As part of the settlement, the HOA also agreed to issue a public statement. It was posted on their website and sent to every homeowner. The Meadowbrook Heights HOA board acknowledges that our previous enforcement actions regarding temporary commercial signage were overly restrictive and inconsistent with the First Amendment rights of property owners. We have amended our covenants to clarify that homeowners may display temporary commercial signs with their consent, subject to reasonable time, place, and manner restrictions. We regret any inconvenience caused to Mr. Aaron Gallagher and to homeowners who were threatened with fines. We are committed to governing our community in a way that respects both our covenants and constitutional rights. The statement felt like vindication, but the real victory was what came after. Over the next few weeks, I got calls from small business owners in 3 other states facing similar HOA disputes. I referred them all to Patricia, who was building quite a reputation as an HOA fighting attorney. She took on 2 of those cases and won them both through early settlements. My own business thrived. The publicity had been incredible advertising, far more valuable than any yard signs could have provided. I hired 2 more employees and bought a 4th truck. I was getting calls from neighborhoods all over the Denver metro area, including several other HOA communities whose boards had quietly decided they didn't want to risk a lawsuit like the one Meadowbrook Heights had faced. In February, I received an interesting phone call. It was from a producer at a cable news network who wanted to do a longer segment about HOA overreach and property rights. They flew me to New York for the interview, which aired during prime time. The host positioned me as a symbol of American entrepreneurship standing up to petty tyranny, which felt a bit overblown, but I understood the narrative appeal. When I got back to Denver, I found that Karen Atwood had moved out of Meadowbrook Heights. According to Tom Morrison, she'd put her house on the market immediately after losing the board presidency and had accepted an offer within a week. She apparently moved to Florida, where she couldn't terrorize the neighbors of Lakewood anymore. The homeowners who'd stood with me, Tom and Janet and Susan and the others, became some of my best clients and friends. They'd taken a real risk supporting me, facing potential fines and legal threats, and I never forgot that. I made sure they always got priority service and discounted rates. The case also changed how I thought about my business. I'd always seen myself as just a guy with a plow trying to make a living, but the experience taught me that small businesses are about more than just commerce. We're part of the community fabric. We employ people, we serve our neighbors, we contribute to local life. When HOAs or governments try to shut down that activity through unreasonable restrictions, they're not just hurting individual businesses. They're damaging the community itself. Patricia and I stayed in touch. She ended up building a thriving practice focused on First Amendment issues, particularly HOA cases. She told me that our case had opened her eyes to how many homeowners were dealing with similar problems, and how often people just gave up rather than fighting back. We'd shown that fighting back could work. One interesting development came in April, when the Colorado legislature introduced a bill to reform HOA governance. The bill included provisions requiring HOAs to justify any restrictions on signs, making it easier for homeowners to challenge unreasonable covenants, and creating a streamlined process for resolving disputes without expensive litigation. The bill's sponsors cited our case in their floor speeches. The legislation passed in June and was signed by the governor in July. It wasn't everything advocates wanted, but it was a significant step toward reigning in HOA power. I was invited to the signing ceremony, which felt surreal. I stood in the state capitol building, surrounded by legislators and activists and other people who'd fought similar battles, and watched the governor put pen to paper. Afterwards, a reporter asked me how it felt to have sparked statewide reform. Honestly, I said, I just wanted to put up some signs and run my business, but I'm glad something good came out of it. No one should have to choose between their livelihood and living in a certain neighborhood. Property rights matter and small businesses matter, and sometimes you have to stand up for both. The settlement money, combined with my booming business, allowed me to expand even further. By the following winter, I had 6 trucks, 8 employees, and contracts with 2 commercial property management companies in addition to my residential clients. I moved out of my small house and bought a larger place with space for equipment storage. I was living the American dream, built on hard work and a willingness to stand up for my rights. The Meadowbrook Heights HOA became something of a model for reasonable governance. Michael Chen proved to be an excellent president, focused on maintaining property values through community building rather than aggressive enforcement. They held neighborhood events, improved common areas, and generally created a much more pleasant atmosphere. Several homeowners who'd been considering moving decided to stay. Property values actually increased, disproving Karen's theory that allowing my signs would hurt the neighborhood. I still drive through Meadowbrook Heights regularly, servicing my clients there. Every time I do, I see my signs proudly displayed in various yards, a small symbol of freedom and reasonableness triumphing over petty authoritarianism. Some of my clients even leave the signs up year-round now, just because they can. The experience taught me several important lessons. First, the law matters. The Constitution isn't just a historical document or a set of abstract principles. It's a living protection that applies to real situations, including disputes over yard signs in suburban Denver. Second, standing up for your rights is worth it, even when it's expensive and stressful and uncertain. If everyone just rolled over when bullies like Karen pushed them around, nothing would ever change. Third, you're never alone. When I thought it was just me against a powerful HOA, I discovered that many people supported me and were willing to help. Community matters. Perhaps most importantly, I learned that small battles can have big consequences. A dispute over yard signs became a federal case, then a media story, then a catalyst for legislative reform. You never know when standing up for yourself might help countless others dealing with similar problems. As I write this, it's been over a year since Karen Atwood first rolled down her window and told me to remove my signs. My business is thriving, the HOA has reformed, and Colorado law is better for homeowners and small businesses. I still can't quite believe that a Tuesday morning confrontation turned into all of this, but I'm glad it happened. I'm glad I didn't back down, glad I found Patricia, glad that Tom and Janet and the others stood with me, and glad that the legal system ultimately worked the way it's supposed to. The First Amendment protected my rights and the rights of property owners to engage in peaceful commercial activity. Karen, wherever she is in Florida, probably still thinks she was right. Some people never learn. But the rest of us, the reasonable people who understand that rules need to serve the community rather than the other way around, we learned an important lesson. HOAs have power, but that power has limits. When they exceed those limits, especially when constitutional rights are involved, they can and should be challenged. I received a letter last month from a small business owner in Arizona who'd heard about my case. She ran a landscaping company and was facing almost identical threats from her local HOA. She wanted advice. I referred her to Patricia and also gave her some practical guidance based on my experience. Document everything, know your rights, don't back down from bullies, and remember that you're fighting not just for yourself but for a principle that matters. She sent me an update 2 weeks ago. Her HOA had backed down after receiving a letter from a First Amendment attorney citing our case. She didn't have to file a lawsuit. The precedent we'd set was enough. That's the ultimate victory, when the mere threat of legal action is enough to make unreasonable people become reasonable. My employees sometimes ask me about the whole ordeal. They know the broad strokes, they've seen the news coverage, but they want to hear what it was really like. I tell them it was stressful and expensive and time-consuming, but also necessary. I tell them that sometimes in life, you reach a point where you have to decide whether you're going to stand up or give in, and that decision defines who you are. I chose to stand up. With Patricia's help, With the support of brave homeowners and with the Constitution on my side, I won. But more importantly, we all won. Every small business owner who doesn't have to deal with unreasonable HOA restrictions, every homeowner who can make their own decisions about their property, every person who believes that freedom matters, they all benefited from what we did. The signs are still up in Meadowbrook Heights, blue letters on white plastic, advertising Gallagher Snow Services. They're just signs, ordinary business advertisements that you'd see in any American neighborhood. But to me, they represent something more. They represent the right to earn a living, the right to speak freely, the right to use your property as you see fit, and the right to push back when petty tyrants try to take those rights away. Karen Atwood thought she could shut me down with threats and fines and police calls. She thought her position as HOA president gave her unlimited power. She was wrong. The law, the community, and basic human decency all proved her wrong. And because she pushed too hard, because she couldn't accept reasonable compromise, she ended up losing everything she thought she'd built. I feel no satisfaction in her defeat. I wish she'd been reasonable from the start, that we could have resolved this with a conversation instead of a lawsuit. But she made her choices, and she has to live with the consequences. As for me, I'm back to doing what I love, running my business, serving my clients, and enjoying the life I've built through hard work and determination. The signs are up, the snow is falling, and Gallagher Snow Services is busier than ever. Sometimes the good guys really do win. Sometimes standing up for your rights really does make a difference. And sometimes a simple dispute over yard signs becomes a story about freedom, community, and the enduring power of the Constitution to protect ordinary Americans against those who would abuse their authority. That's my story. From a Tuesday morning confrontation to a federal lawsuit to legislative reform, all because I refused to accept that an HOA president could violate my rights and the rights of my clients. It wasn't easy, and I wouldn't want to go through it again, but I'm proud of what we accomplished. And every time I drive through Meadowbrook Heights and see those signs, I'm reminded that freedom isn't free. Sometimes you have to fight for it, even when the fight is over something as simple as where you can advertise your snow removal business.